Today we'll be covering Freedom of Expression, which is Chapter 2 in Digital Media Law, 2nd edition by Ashley Packard. Our book says no other country protects freedom of expression more vigorously than the United States. Some say we go too far, and we do sometimes wind up protecting speech that doesn't really contribute much to the common welfare. Sometimes we neglect other important rights, such as the right to privacy and the right to reputation, because we value free expression so much. Our culture and our political heritage and history influence the way we handle speech and expression in the United States. Other parts of the world have different philosophies. France and Germany, for example, are sensitive to hate speech because they went through the Nazi era during World War II. European countries in general are more sensitive to defamation or concerned about people's reputation being harmed because they have a history of feudalism and class divisions. But American colonists, when they founded our country in the 18th century, were looking for religious, economic, and speech freedom, so they put it in the Constitution. The First Amendment to the U.S. Constitution is the foundation for our freedom of expression. It is quite beautiful. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peacefully to assemble and to petition the government for redress of grievances. Let me explain a couple of terms there. The establishment of religion means designating a state religion, and petitioning for a redress of grievances means asking the government to fix something that you think is wrong. So the elements of our First Amendment are freedom of religion, freedom of speech, freedom of the press, freedom to peacefully assemble, and freedom to petition the government seeking correction of grievances. Since Donald Trump became president, U.S. citizens and residents have acted on their right to peaceful assembly and petitioning for a redress of grievances. They have assembled and petitioned to criticize the president, the policies he has sought to introduce, and others that would take away current rights and make them illegal. Here you'll see an article from the New York Times talking about Donald Trump's inauguration in 2017 as a time that was filled with both protesting and planning, including in those protests were people saying goodbye to former President Barack Obama. You can see them pictured here. Others protested Donald Trump's inauguration itself because they do not support his policies and his personal behavior. Because of our freedom of expression in the United States, they were able to say what they felt. In the meantime, people who do support Donald Trump and his policies also had their say on the streets, kind of a counter demonstration to what Trump's opponents are saying. Just last year, the state of Alabama had demonstrations in the capital, Montgomery, after the governor signed what's called a heartbeat bill, which bans abortions after a heartbeat has registered. Since Donald Trump took office in 2017, women's marches around the world have taken place and have been opportunities to protest Trump's policies as well as the treatment of women around the world. In 2019, protesters once again peacefully took to the streets to protest inaction related to climate change, both here in the United States and around the world. The author of our textbook says, the First Amendment's protection for speech and press is foundational to U.S. media law. It distinguishes our national approach to such issues as defamation, hate speech, and obscenity from those of other Commonwealth and civil law countries. Other nations have included protections for expressions in their constitutions, but they do not guarantee that of speech and press freedom as broadly stated as the First Amendment. It is indeed a sweeping statement. It's grand and it's broad, but the flip side of that is that it is subject to interpretation by the courts and others. It doesn't always turn out to mean exactly what one person might think it means. It may be what somebody else thinks it means because it is so broad and somewhat vague. One question that comes up is, what constitutes the press in this day and age? When the Constitution was written, the press consisted of newspapers, magazines, and books. Those are certainly still considered the press, but now you have other forms of journalism that do not necessarily involve a printing press, such as radio, film, TV, websites, blogs, podcasts, video, social media, and the list goes on and on. So one decision the courts have to make ongoing is what constitutes protected media. Another question that comes up is how absolutely should the text be followed? Some of our Supreme Court justices have taken the position that it's pretty absolute. There are virtually no exceptions. One of the champions of First Amendment freedoms was Hugo Black, who is a Supreme Court justice in the 20th century and who also grew up in Alabama. This is an expression he made in a dissenting opinion in a Supreme Court case in 1961. Notice the word dissenting. That means this was his opinion, but it did not carry the concurrence of the majority of the Supreme Court. So it's not actual law. You might say legal philosophy that at one time or another might become incorporated into law if enough justices, especially Supreme Court justices, signed onto it. Justice Black said the First Amendment's unequivocal command that there shall be no abridgment of the rights of free speech and assembly shows that the men who drafted our Bill of Rights did all the balancing that was to be done in this field. In other words, he is arguing that the First Amendment is supreme. The First Amendment protects government suppression of expression, but not private suppression. You can say what you want to as far as the government's concerned, pretty much. You can say as much as you want to as a citizen. But as an employee, you're subject to what your boss wants you to do. You do not have some protection from unreasonable retaliation, but your boss obviously has a lot of influence over your circumstance, so he might try with some success to tell you what you can and can't say. A lot of us are reluctant to speak out about certain issues because we know they are sensitive with our employers, even though we may feel strongly about them. Your web host could kick you off the internet, make you go find at least another host, and we see decisions like this being wrestled with by big companies like Facebook and Google because they are struggling with whether and how to manage fake news these days. They realize that fake news may have gotten out of hand, so Facebook is making it easier for readers to know who the news organizations are behind specific stories to help stop the spread of fake news. Another solution digital companies have worked on and implemented is to take away the advertising revenue they had been given. More or less, because people looked at a site and they're paying more attention to the content of those sites. Google, for example, is not offering advertising revenue for certain sites that it considers to be fake news. The First Amendment protects speech from government at all three levels: federal, state, and local. This hasn't always been the case. At first, the Supreme Court said that the amendment applied only to the federal government. You may notice the amendment says, Congress shall make no law. Congress being the federal government. But in 1866, the 14th Amendment was ratified, saying that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, and in 1925, the U.S. Supreme Court declared that because of the 14th Amendment, the First Amendment applies to the states. The same isn't true for the entire Bill of Rights. Supreme Court is held at only fundamental rights regarded this way, including speech, press, religion, assembly, association, petition, private property, and protection from unreasonable searches and seizures and from cruel and unusual punishment. The latter items in this list are not in the First Amendment. They're elsewhere in the Bill of Rights. In the 1990s in Alabama, we had an interesting and colorful governor who was at odds with the federal government on certain things. The issue at hand was whether the Ten Commandments could be displayed in the courtroom, and he took the position that the First Amendment did not apply to Alabama, just the federal government. He was actually concerned about religious freedom at that point, but I was thinking of the implications that something like that might have for the press if the state of Alabama, or any state, does not have to respect the First Amendment and is able to censor the press. That can make a lot of difference. The point of view is not prevailing, and the state of Alabama, to my knowledge, has never tried to censor the press or censor speech by its citizens. I want to explain this term called prior restraint. Prior means before. And what prior restraint means is that you can't stop somebody from publishing or saying something. In 1931, the Supreme Court said prior restraint would only be used in exceptional situations involving such things as military recruitment, ship sailing dates, the locations of troops, obscenity, incitements to violent overthrow of government, and protection of private rights such as fair trial and intellectual property. In 1971, the Supreme Court said the government could not stop newspapers from printing classified records called the Pentagon Papers of the Vietnam War. This is a very significant case for media freedom in the United States. But in 1979, the Supreme Court stopped a magazine from publishing directions to manufacture a hydrogen bomb. I suspect it was probably because of the public safety concerns. That case mirrors one that is more recent. In 2019, a federal judge in Washington state blocked the Trump administration from allowing blueprints for making plastic guns on 3D printers to be posted on the internet. The ruling, which is likely to be appealed, stoked a long, fierce debate over 3D printed firearms. Proponents have asserted that there is a First Amendment right to publish such materials, while critics have argued that allowing 3D printed firearms could lead to increased gun violence and allow criminals and terrorists to skirt gun control legislation. The judge's ruling also did not directly settle the First Amendment arguments raised by those who support the blueprints publication, because the State Department has not attempted to justify its action as compelled by the First Amendment. This is a case that you may want to keep checking in on because there hasn't been that direct relationship to the First Amendment and why it can or cannot be published. In 1976, the Supreme Court limited the circumstances in which the judge can impose a gag order to achieve a fair trial. A gag order is where the judge tells lawyers and other parties in the case that they can't say things to the media. And also, the judge may try to tell the media what they can print or they can't while the trial is going on, in the interest of making sure the defendant gets a fair trial. The Supreme Court said that prior restraint on speech and publication are the most serious and the least tolerable infringement on First Amendment rights. Now, the First Amendment has also been held to protect Americans from suppression of speech after publication. It's not just against prior restraint. Some of those protections developed during the 20th century. An interesting case where people who generally support free speech are sometimes at odds with the prevailing law that's intended to protect free speech has to do with political advertising. Now, you can speak out anytime you want to about a political candidate, but if you want to speak out effectively to reach a lot of people, you have to spend money, mostly through advertising. So the Supreme Court has protected political spending on grounds of the First Amendment. In 2010, in a case called Citizens United versus the Federal Elections Commission, the Supreme Court said that limiting corporations' campaign spending for or against a candidate just before an election violates the free speech of those corporations. Citizens United has become a bone of contention, though, between U.S. politicians, many of whom think that there's too much money in campaigns and it distorts the power. Certain people who have money, it gives them too much power and keeps people who don't have money out of the political process. So you have many liberals and members of the Democratic Party saying that because of this policy, it encourages corruption in government, gives money more influence, makes politicians or eager to please campaign contributors less willing to serve the common good because of all those things. They'd like to overturn Citizens United and regulate campaign spending more strictly. Conservatives and Republicans, for the most part, are defending Citizens United. Overturning it would not be a simple deal. A change of direction by the Supreme Court might result in modification or overturning a Citizens United, but that probably is not going to happen until some justices are appointed who have a different view of these issues. A constitutional amendment could overturn it, but that would require action by Congress as well as ratification by a large number of states. The level of protection of free expression depends on the category of speech. Political speech is fully protected. Commercial speech, such as advertising, is protected as long as it is true. In other categories of speech, such as obscenity, are not protected. We'll go into more details about some of these in later chapters. Protection of speech may vary depending on the medium used to convey the speech. The word medium is the singular of media. So when we speak of the media, that's more than one news organization. A medium is a single news organization. Protection of speech also depends on whether the speech occurs on government property and whether the speech is expressed through conduct, whether the speech is student speech. Students in education environments don't necessarily enjoy the same protections as people at large. First, we'll talk about different media. Print media gets maximum protection. The press are named in the Constitution in the First Amendment. The broadcast media, though, have to use the public airways to broadcast, so the government regulates them more closely. They must be licensed by the Federal Communications Commission, and they must comply with content restrictions based on how widely they circulate and their accessibility to children. Cable TV, which relies on public rights-of-way for its lines. In other words, they have to put cable along the sides of streets in order to serve their customers. Those are public streets. Cable TV must carry signals from local broadcast stations so they don't get shut out of the way customers view television. However, cable is based on subscriptions. In other words, people pay to use it, so cable is generally free from restriction on its content. You'll see the language on cable TV is much more raw and explicit than it would be on broadcast channels. Satellite television, which is also a subscription medium, must save some of its capacity for educational programming and for local stations, but its content is not censored. When the internet came along, the question was, how do we regulate this new medium? And at first, the government tried to regulate the internet, but in 1997, the Supreme Court concluded that, like print, the internet is worthy of full First Amendment protection. When speech occurs on public property that is not reserved for speech purposes, the government may impose non-discriminatory restrictions on the time, place, and manner in which the speech is conducted. Non-discriminatory means being content neutral, not censoring based on content. Not all expression is in the form of speech or writing. Sometimes it is nonverbal. Sit-in demonstrations where people occupy, say, a dean's office or lunch counter in order to make a point. Those are expressions of opinion, and they are often protected by the First Amendment. Burning flags, we've had quite a controversy in the United States from time to time about whether it should be legal to burn the American flag. It is an expression of opinion. So somebody expressing contempt for something the government is doing, his or her flag burning may be protected expression. Computer code and computer programs are forms of speech that are covered by the First Amendment. We have an ongoing controversy in the United States right now that started with a few professional football players who decided to kneel at times during the playing of our national anthem before ball games. They are protesting because they say that Black Americans have been mistreated, brutalized, and harassed by police officers. This has become a movement with players of other sports and at the college and high school levels showing their support by also kneeling. President Trump and other people have denounced these protesting players, saying that they are unpatriotic, but it hasn't stopped the players from exercising their freedom to express themselves. The government can't stop them. Maybe the owners of ball teams could stop these protests if they wanted to, but they seem reluctant to do so. Let's talk for a moment about the freedom enjoyed or not enjoyed by students. Speech and internet postings and other publishing by students are protected but within limits. Different rules may apply for college students than for younger students. College students generally have more liberty to publish inside school newspapers or on school campuses than younger students might in high school and in elementary school. Different standards may also apply for public schools versus private schools, public schools being those supported by the taxpayers. Now I have some material here that is not in the textbook that comes from the Student Press Law Center, which is a U.S. advocacy group, and it takes the position of the 1969 case known as Tinker, which set the standard regarding students' free expression rights in U.S. public schools and colleges. Specifically, the Student Press Law Center says that under Tinker, student expression may not be censored because it is controversial, because school officials dislike its content, or because it offers harsh criticism of them and or their school policies. Student editors have the right to make all decisions related to the editorial and advertising content of student media. Now, Troy's student newspaper, the Tripolitan, has faced issues related to freedom of expression and attempted censoring. This was a long time ago, but it was big news statewide when it happened. Gary Dickey was a student editor of the Tripolitan student newspaper. He wrote an editorial in 1967 defending freedom of speech at the University of Alabama and criticized members of the Alabama legislature. Now, the university, which was then known as Troy State College, considered criticism of the legislator to be against policy because the legislature was, in a sense, the owner of the university because we are a public university. So Gary's college advisor and president of the university told him not to publish the editorial. So when the newspaper came out that week, Gary printed the headline of the editorial along with the words censored placed diagonally across the blank space where the text of the editorial would have been. He also mailed the censored editorial to a newspaper in Montgomery, the capital of Alabama, where I believe it was published. Consequently, Gary Dickey was kicked out of Troy State College and he sued in federal court. The judge found that Dickey was expelled from Troy State College for exercising his constitutionally guaranteed right of academic and or political expression. The judge ordered the college to reinstate Dickey, and we still, these many decades later at Troy University, honor the principle laid down in that court order. Here is an actual copy of the page of his article in the Metropolitan in 1967, where the censored editorial was not printed. Now, I wanted to show you this because it shows Troy perhaps learned its lesson from what happened in 1967. The Chancellor of Troy University was quoted in the Metropolitan in 2014 as saying that freedom of expression is essential to both the personal and professional growth of all our students here at Troy. It said it is critical to educate students to communicate civilly with everyone around them, even if the way the other person thinks is foreign to them. The previous advisor to the Metropolitan, who was also quoted in that story and is a former journalism professor, said, "My main concern as Metropolitan advisor is to help them be professional. My goal is to help the students put out high quality work and to help them focus on material that will serve their readers. Nobody has ever told me that it is my job to censor the Metropolitan, and I certainly do not think that is my job." Professor Stewart said that Troy University today is a place of free speech, and he does not see anything that prohibits students from expressing themselves. He said he cannot foresee another situation happening like the Dickey case. Because of its large international presence on campus, it is a sign that the university values what every individual brings to the table and can learn from others. Troy is proud of its diverse student body, and it does mean our student media is both run by and created for students whom are different from one another, from where they grew up to their personal, political, and religious beliefs. It contributes to a robust and productive educational environment, just the opposite of what happens when you clamp down on free speech. I want to mention one more point here. Government cannot compel speech. It can't make you say something that you do not believe here in the United States. So why do we have the First Amendment? The book offers several possible reasons, all of which may have figured into the Founding Fathers' thinking when they wrote the amendment. First is the freedom of expression is required for self-government. Essentially, people need information in order to make good decisions when they vote for their representatives and when they petition for certain policy. Free expression allows them to find out about abuses of power, and it resulted, for example, in the 1974 resignation of one of our presidents, President Richard Nixon. Probably indirectly, at least, because the news media found out about the Watergate scandal that his people were involved in and pursued that story without being restrained by government. Second, freedom of expression acts as a safety valve. It's a way to express your differences without being violent. One of our Supreme Court justices said that sunlight is the most powerful of all disinfectants. He said the fitting remedy for evil counsels is good ones. In other words, the theory is that if you disagree with what somebody says, the remedy is not to stop the person from speaking, but to express your point of view to counter what you may consider to be bad information with good information. Another reason is freedom of self-expression is required for self-fulfillment. All of us have certain things we're good at and want to do, and we should be free to inquire and to express ourselves and be ourselves. And then freedom of expression helps us find the truth through what we call the marketplace of ideas. Everybody who wants to put information and opinions out there, and we shop as consumers to determine what we think makes the most sense and fulfills our objectives. Now, it used to be that you really didn't have much freedom of press, for example, unless you owned the newspaper or company. These days, with digital media, everyone, just about, has access and can participate in the marketplace of ideas. You can express your opinions online, and sometimes individual opinions can create currency that would be very difficult in the past when you had to be filtered through a person or the news media. The marketplace of ideas can work to filter out through a good process that has bad information to replace it with good information. You see in Wikipedia how that can happen. Somebody puts an article on Wikipedia and other people edit it and correct it. And if somebody makes an untrue statement, the theory at least is that eventually somebody will come back with good information and fix it. Now that's a good example of the way a marketplace of ideas works. You may know that Wikipedia is not a very good place to do academic research because you don't know who has been editing it. And at any given point, there may be inaccurate material. Questions to consider and discuss from this chapter. Why is it important that First Amendment freedoms apply not just to the federal government, but also to state and local governments? What does it mean for a restriction on expression to be content neutral? How much freedom do you think college students should have to speak out on campus and through student media such as newspapers, radio, and television? And how free do you think you feel to state the facts and to express your opinions on campus and society? I hope you will consider these and participate in our class discussion, and I will talk to you very soon. Have a wonderful day.